Today we're going to review the parole evidence rule that we talked about in class. We're going to talk about the three major cases in this chapter, and then we're going to talk a little bit more about collateral agreements before concluding with a conversation about how to use this rule. And I have a flow chart for you to work through on this subject. And so we'll get started just by reminding ourselves that the parole evidence rule has effectively just two functions. The parole evidence rule, one, bars the admission of evidence that would modify a final written term, and it bars admission of extrinsic evidence that adds terms to a fully integrated agreement. Now, we're going to have to unpack that language, and we're going to have to analyze whether an agreement is fully or partially integrated, and we'll also have to understand what the evidence is intending to do. So it's really a two-step process. We first evaluate what is the nature of the agreement, whether it's unintegrated, fully integrated, or completely integrated, and then we ask what's the nature of the evidence to be produced. Is the evidence to be introduced in order to modify a term, to add a term, or to explain a term, or even for some collateral purpose? The PER does not do several things. So the parole evidence rule does not serve to exclude evidence that would explain the meaning of an ambiguous term. So to be clear, in any court, in any jurisdiction, if the contract is patently ambiguous, if on its face you can't read it and make sense out of it, that court will admit extrinsic evidence to explain the meaning of that patently ambiguous term. We discussed in a couple sessions back whether a court would admit extrinsic evidence to show the contract had a latent ambiguity, an ambiguity not on the face of the contract, but when seen in the context of the commercial situation, it turns out that the parties maybe did not write down what they intended, or that the objective meaning is not necessarily the subjective intention of the parties. That's a trickier issue, and that is, not, again, not a parole evidence issue. That depends on whether the courts take an objective or a subjective approach to contract interpretation. And so evidence of a latent ambiguity is also not something barred by the parole evidence rule, but some courts will not admit evidence of a latent ambiguity when the contract has no patent ambiguity. That's separate from the parole evidence rule. That has to do with the jurisprudential philosophies of subjective and objective theory of contracts. We also will always admit, at least for contracts that are governed by the UCC, and as a reminder, contracts are governed by the UCC when they are for sales of goods, and goods are things that are movable and identifiable at the time of sale. We will always admit, at least for contracts governed by the UCC, evidence of course of performance, evidence of course of dealing, and evidence of usage of trade. The parole evidence rule also does not bar collateral agreements, and we're going to talk a little more today about what makes something collateral. How do we determine what is collateral versus what is essential? It turns out that it's a facts-based analysis, and we're going to have to go through some reasoning to determine which category you put something in. We also are not able to use the parole evidence rule to bar evidence that a contract was not formed. Because if the contract was not formed, then the writing is not actually a meeting of the minds and is not enforceable. And so we will admit evidence of a defect in contract formation. The parole evidence rule does not touch that. And finally, the parole evidence rule does not prohibit evidence of a subsequent modification. Contracts can be freely modified by the parties at any time. They can choose to modify their contracts. Now, of course, the contract can specify how it can be modified, and we have the pre-existing duty rule, which has some limitations on modification without consideration, etc. But those are not parole evidence rule concepts. Those are separate concepts. And since we have read many of these cases, and we'll read a few of them, I just want to remind you that we do have a case that stands for all of these concepts. The modification of final agreement, that was Middletown Concrete. Additions to complete agreements, that came up in United Auto Workers. Introducing evidence to show the meaning of an ambiguous term came up in Fregalement and Clapp. Evidence of latent ambiguity, that was in C&A and PG&E. Collateral agreements, that was in Seagram's. Course of performance, course of dealing, and usage of trade, that was Nanakuli and defects in contract formation, that was all in Contracts 1. And by the way, I see some of you writing it down, but you may recall I sent an email last night containing all of this information, including the cases, as a sort of a semi-outline. So of course, you're welcome to write it down again. But you should have this in your inbox. And so I want you to be clear as to what are the cases at issue here. So don't worry about necessarily scrambling to capture all that. When you are presented with a fact pattern dealing with contract interpretation, you have to make a choice whether to go about doing a parole evidence rule analysis. It's not a short analysis, and so deciding whether or not you actually have to do the analysis is really the first step, or the preliminary step to the analysis. So you don't end up wasting your time writing an essay about parole evidence where that issue is not presented by the facts. So we should think about what types of issues, what types of facts will raise this issue. Well, we're always going to have a written contract. If there's no written contract, there cannot be a parole evidence rule issue. That one's pretty clear because the parole evidence rule only prohibits the introduction of evidence that would add or modify a term in a written agreement. If the fact pattern does not contain a written agreement, there is no reason to proceed with this analysis. The parole evidence rule simply does not apply to that circumstance. We'll also have a party seeking to introduce extrinsic evidence, and that means that the party is not arguing what the contract means based on its four corners, but is making a statement about what the contract should mean based on some other fact, like course of performance, course of dealing, usage of trade, or preliminary negotiations. So you will see one of those categories of extrinsic evidence, something from outside the four corners, being introduced. And moreover, that information, that introduction of evidence, would modify a term in the writing. And so if you don't see facts that jump out at you like that, then it's probably not a parole evidence rule question. And it's not a good use of your time to then perform the parole evidence rule analysis, concluding that it doesn't apply if it does not apply on its face. And the most obvious one, again, is the lack of assigned writing. If you don't have assigned writing, you're not being asked a parole evidence rule question. So that's step number 0, if you will, the preliminary step. What's step 1? Well, we first ask, what's the nature of the writing? Now, that writing can be unintegrated, integrated, or we'll call that a final integration, or completely integrated, also known as complete and exclusive. All contracts, all writings will fall into one of those 3 buckets. Unintegrated essentially means it's a draft, it's not yet final. Final means what it says. Those are the final terms. And complete and exclusive, well, it also means what it says. That is the entire agreement. Those are all the terms. They're not just final, but they are a complete universe. And once we've determined that, we can then ask, what is the nature of the evidence introduced? And by answering that question, we should get to a resolution as to whether that evidence comes in or whether it's barred by the parole evidence rule. Different statutes or common law use different terminology that means effectively the same thing. So here's a little handy-dandy chart for you to keep in mind where we're talking about what are effectively synonyms. If the concept is, if the intention of the parties is that the paper in front of you has written terms that are meant to supersede any conflicting terms, that what is written down here is going to knock out anything that conflicts with what's written. That is called a final agreement in common law, a final agreement under the restatement. The UCC calls that integrated and sometimes calls that partially integrated. Right? And those are all synonyms. When we have an intention of the parties that the writing will supersede all terms, both conflicting and additional terms, well, that's a complete and exclusive agreement under the restatement, under common law, which is synonymous with a complete integration, also known as a total integration or a totally integrated agreement under the UCC. And so that bottom row there, those are, again, also all synonyms. And so you can use whichever language you choose, but I do recommend that you try, at least, to use the UCC terminology when analyzing a contract governed by the UCC, and you use the restatement terminology when you're dealing with a contract that is governed by the common law. That would be the appropriate convention. Failing that, it's best not to mix the terms because that could create some confusion. So if you choose to use one or the other all the time, that would be the second best approach. But it would be confusing if you sometimes called a contract final and sometimes called it a total integration, because then you would be using one from column A and one from column B. So again, we have common law terms which apply in common law cases, UCC terms which apply in those statutory cases. It's best to use the right terms in the right places, or at least be consistent with your usage, even though these are synonyms. Let's define some of these things then. So first, we have the definition of a partially integrated contract. How is a partial integration defined? And by the way, sometimes it's called a partial integration, sometimes just an integration. Now remember, in our Venn diagram of life, every complete integration is also effectively a partial integration. It's a partial integration and more. It's final and exclusive. And so we can think of integrated, or we can be specific. When we say partially integrated, we mean the part of the Venn diagram which is in the larger circle but not within the smaller circle. So a partially integrated contract or an integrated contract is a writing or writings constituting a final expression of the parties, of one or more terms of the agreement. Right, and so that's our just standard definition. On the other hand, a complete or totally integrated contract is an integrated agreement. So, right, first off, it's an integrated agreement, but it's more than that. It's an integrated agreement that is adopted by the parties as a complete and exclusive statement of their terms. Okay, fine. Definitions are all good and well. You can read those in the restatement. You can read those in the UCC. You can read them in Black's Law Dictionary. And by the way, all three sources are very consistent. But what do those definitions mean? Well, we need to determine the nature of the writing, and we can do that using our two tools, intrinsic evidence and extrinsic evidence. This is why it's well situated in our chapter on contract interpretation. We use the same interpretive methods to make meaning out of the contract terms regarding integration as we would for any other contract term. And we're going to read the contract to determine whether or not it is in fact integrated or not. The best evidence, the clearest evidence at least, of a contract being integrated is it will possess in its four corners, intrinsically, a merger clause. A merger clause, or an integration clause, is the document telling you that it is completely integrated. It will say something like, this contract, this writing, is a complete and total integration of all the terms the parties contemplated for this deal, and it supersedes and excludes all other terms. It actually tells you on its face that it is completely integrated. Should you believe the contract? Well, that depends if you take a subjective or an objective view of contracting. If you're a firm, objective theory proponent, and some judges are, well then, a merger clause that is unequivocal will be dispositive. By which I mean, if you believe that writings can prove themselves, and this writing tells you, I'm complete and exclusive, you believe it and you move on. And that's what happened at United Auto Workers. On the other hand, some courts are much more apt to introduce extrinsic evidence to obtain the subjective understanding of the parties. Because contract law is really about understanding parties' subjective intent and giving them what they wanted from the deal. And so some courts, even when presented with a patently unambiguous, clear, plain, and obvious merger clause, will still admit additional evidence to determine whether or not the parties really intended that. The case for that is Sierra Diesel. That's what happened in Sierra Diesel. Now, still, intrinsic evidence is usually going to be very strong evidence, and then we also have our extrinsic evidence like preliminary negotiations and other features about the context of the deal. So the stuff that we learned, therefore, about objective and subjective very much comes to bear on how we read merger clauses. If a court is a strict objective theory court, it will rarely admit extrinsic evidence when the contract is clear. And we're simply applying that in the specific case of a merger clause. So if you understood that an objective court will not allow extrinsic evidence that contradicts the plain meaning of written terms, you would not be surprised that an objective court will not admit extrinsic evidence that contradicts a plain and unambiguous merger clause. On the other hand, a subjective court will generally admit extrinsic evidence unless the intrinsic evidence is not susceptible to any additional meanings. And so there is some balancing there. Subjective courts don't open the gates wide, but they generally tend to hear more evidence. What's this merger clause thing? Well, we looked at a couple of them, and I recommended that in all of the cases that you have read, maybe use a special color highlighter to note the merger clause, right? You identify it. They don't always call themselves out, although in good drafting, there's like a heading that says integration clause. This contract is a complete and exclusive statement and says it very clearly. That would be the best thing. But it's any type of objective on the paper within the four corners statement by the document that it is a complete and exclusive set of the parties' terms. In other words, the writing will claim that it is either a total or a complete integration. And so it's actually by reading the contract, what does it say? Does it say the terms are final? Does it say the terms are complete and exclusive? What does the merger clause say? It's just another piece of extrinsic evidence. And as I mentioned, courts do take different approaches. And as a reminder then, you can look at United Auto Workers, which is our case where we saw a strict objective theory applied to a plain and unambiguous merger clause, resulting in barring extrinsic evidence that would have added a term to a complete integration. And on the other hand, we have seen the subjective approach. We will talk about a little more. We saw that mainly in the dissent of United Auto Workers, but we also see that in Sierra Diesel. Since we already talked about United Auto Workers, I'll just talk about it very briefly and give you a reminder of sort of the key facts here. But what do you need to remember about this case? This was the case where the majority took the objective approach. And by taking the objective approach, they determined that a clear and unequivocal merger clause would exclude extrinsic evidence of preliminary negotiations that were being sought to add a term. And so in this case, we had United Auto Workers contract with CMC, who later sold to KSL. UAW and CMC had a contract for services, for convention services, and the contract did not say anything about using union employees. Didn't say anything about it. Turns out that UAW and CMC had that conversation. There was some preliminary negotiations, but it was never written down. And the contract had a merger clause. KSL inherited this contract, and after inheriting it, held the conference, did not have union staff, or was going to hold the conference without union staff, and UAW tried to back out of the deal and asked whether or not they could admit this extrinsic evidence. In fact, the question was effectively whether a plain and unambiguous merger clause precludes evidence, oral evidence, of prior negotiations. Yeah, and so that's this general concept here, right? So this is our big case about an express, explicit, patently unambiguous term. Is it going to be dispositive? Well, the answer depends on the court's jurisprudence, and so the majority took the objective approach. And the majority, using the objective approach, said, absolutely. When you have a clear, clean, and unambiguous term, we will not admit extrinsic evidence to change its meaning. And moreover, since that term was the merger clause, we won't admit extrinsic evidence for any other purpose that would modify or add a term either. The dissent, with the subjective theory, said that black letter law will result in a harsh effect on United Auto Workers. We want to be nice to them. So more than that, they cited to Corbin, who said that a contract cannot prove itself. The idea that you should always admit extrinsic evidence, right? You've seen this a dozen times by now. This is the subjective theory of contracts, just applied to a merger clause. In Sierra Diesel, we saw a little bit of a different story. In Sierra Diesel, as you may have remember from the reading, we have a case about a sale of a bookkeeping machine, which we now call a computer. That's what they actually looked like in the age of this case. It probably predates most of your existence on this earth, but they used to have these giant computer machines, and they were not quite as powerful as your iPhones. And what was interesting about this case is it involved a Luddite. It involved a buyer who was not sophisticated, right? And I picture my grandmother is, trying to send email, and she's calling me, and, these kind of questions. So this is an individual who's not at all versed in computers, and so was entering into a contract for the purchase of this fairly complex computer machine. And in the process of buying this machine, the salesman made some representations about what the machine would do. And they weren't true. I mean, he just made stuff up. He said the machine would do things it couldn't do. Okay? And, okay, so the guy believed that the computer could do all these awesome things that would meet his business needs, and so he signed a contract to buy it. And the contract said there are no representations or warranties except those contained in this contract, and this contract is complete and exclusive. In other words, it had a merger clause, and it had a clause that disclaimed all warranties, meaning the preliminary negotiations between the salesman and the buyer, those were preliminary negotiations, right? They're talking, what can the machine do? Oh, it can add 600 calculations a minute. Wow. This is 70, so maybe that was a lot. But it couldn't, right? But there were actual representations made about what the machine could do. The machine couldn't do it, but those representations were made prior to the signing of the contract. They were not written in the terms. Therefore, they are preliminary negotiations. And so the question is whether the integration of the written agreements would then preclude the introduction of evidence to show that these parties had that conversation. We have a writing. The writing has a merger clause. The merger clause says this is a complete and exclusive statement of all the parties' terms. And on top of that, there's a term that says there are no warranties. There are no promises except what are written down here. But our buyer, who was bamboozled, wants to introduce evidence of preliminary negotiations, wants to introduce extrinsic evidence showing that in fact there were promises made. Will the merger clause preclude that evidence? Well, under the objective theory, it would, because the merger clause is plain and unambiguous. But the Sierra Diesel Court, as I mentioned, does not take the objective approach. The Sierra Diesel Court takes the subjective approach and says that even interpreting a plain and unambiguous merger clause requires getting into the subjective mindset of the parties. And so they actually look at extrinsic evidence to determine whether or not they really meant the merger clause that they wrote. They're not going to believe the contract. Subjective courts don't trust the contract. They want to hear from the parties themselves. And so the analysis proceeded that a reasonable person in buyer's position would have no idea what he was doing, right? I mean, he had no idea what an adding machine or a bookkeeping machine did, and he was given a bunch of lies. He didn't even understand the integration clause. Now, look, as I mentioned, I generally support the subjective theory, but this is sort of one of those out there cases. This is really an extreme example because the buyer didn't know anything about computers, but he was a business person. He wrote contracts all the time. I get that he didn't understand the salesman's lies about how many additions per minute or how that mattered for the purposes he needed. But here was a guy who should have understood what a merger clause was. So I'm not sure I'm totally buying the court on that one. In any event, they take a really strong subjective approach and reach the conclusion that there was no mutual intent for the contract to be integrated. Since there was no actual intent, they felt the extrinsic evidence outweighed the intrinsic evidence. And so they dismissed the merger clause. Even though it was plain and unambiguous, they still allowed evidence to be presented which said the parties didn't mean the contract to be integrated and intended those representations and warranties to be included. Therefore, the promises about how many calculations per minute were introduced as evidence, were admitted as terms in the contract, and a breach of contract claim was therefore won by the buyer because the merger clause was not respected by the court. Again, this is an example of an extreme subjective viewpoint, but it really highlights the subjective view of contract theory as applied to the interpretation of merger clauses. We have a clear and unequivocal merger clause, and despite that, one party is able to admit evidence that that is not what they really meant, and it succeeds. Dakota.
I know the court took a subjective approach to this, but could the unsophisticated businessman say that the computer salesman acted fraudulently in order to get around the parole evidence rule?
So That's a great point. So what about claiming that there was fraud on the part of the salesman? So in contract speak, well, first off, there are other claims about fraud, and we can talk about that in torts class. But in contracts class, we would talk about a fraudulent misrepresentation. And a fraudulent misrepresentation is an example of a defect in contract formation. Mistake, misrepresentation, undue influence, duress, infancy, et cetera, public policy, all are types of defenses to contract formation. And as Dakota pointed out, could they have introduced evidence of this fraudulent misrepresentation? Yes, they could, but what would the effect be? The effect would be to say the contract never existed. It would destroy the contract. And I wasn't there in the room when the lawyers were deciding their litigation strategy, but I can only presume that they felt their client, the buyer's interest, would be better served by saying there was a contract and it was breached, as opposed to saying there was no contract at all. Maybe they didn't want rescission. Maybe instead of effectively tearing up the contract as if it had never existed, you return the machine, you get your money back. Maybe this caused damage above and beyond the amount of the value of the machine. And they wanted to get those expectation damages, which can be more than rescission damages. We'll cover that more in the damages module, but that's what I would expect. You're absolutely right. They could have made a fraud claim. We'll call that fraudulent misrepresentation claim. That would have been introduced as evidence because it is evidence of a defect in contract formation, and the Parol evidence rule does not bar that evidence. Question, Veronica.
So because they excluded, like they said the merger clause wasn't, like, I guess, even for the contract, was that contract then, just a final, like, integrated term? Is that what we're saying? And that's why they were allowed to admit it? It wasn't exclusive?
Yes, they were saying that it was not complete. Okay. It was not complete. And so the merger, they didn't believe the merger clause. And so I don't think they actually, so Veronica's asking, was the contract then unintegrated or finally integrated? It wasn't completely integrated, right? We have three categories. Was it a draft that wasn't integrated at all? Was it a final integration? Or was it a complete integration? Well, since this was an additional term, it doesn't matter if the contract is final or draft. So I don't think they resolved that issue. At least, they might have at a lower court. I didn't read that part of the opinion. But it doesn't matter for the purposes of admitting evidence of an additional warranty, because they were adding a term. Although, as I'm saying that, there's a counterpoint. Henry might know, because Henry brought this point up in our last class. No, I'm not. I'm giving you credit, but here's what you're thinking, Henry. See, what Henry's thinking is, wasn't there a clause? But wasn't there a clause that says there are no representations and warranties? And by adding a representation and warranty, aren't we modifying that clause? And therefore, a final integration would not permit introduction of evidence that would modify the clause that says there are no other promises? Great thought, Henry. I'm not entirely sure on that one. I'll have to get back to you. But thanks for bringing that up. I think that the court found this was adding a term, and since that they simply had to decide was it a complete integration or not. And more than that, the court was like ready to throw the book at the bookkeeping machine salesman, and so I think part of it was just they didn't like that he was lying to get his business done. So there was kind of that aspect too. Dan.
So what I'm taking from this is that the approaches in Sierra Diesel and UAW is to show us, do we believe a merger clause on the issue of integration?
Right.
The objective court, like in UAW, they're going to believe that, and a more subjective court, like in Sierra Diesel, they're not necessarily going to believe it.
Exactly right.
Okay.
Alec.
So can a contract only be completely integrated if there is a merger clause?
Good question. There can be other, so even the lack of a merger clause is good evidence that a contract is not completely integrated. But there can be other evidence that a contract, even without a merger clause, is completely integrated. Like if it's extremely complex, has been negotiated for a very long period of time, and appears to contain all of the terms, you can admit extrinsic evidence doesn't always disprove integration. Sometimes it can prove integration as well. Yeah, so the most common cases, you have a merger clause and courts believe it. The less common cases, you have a merger clause and courts don't believe it. The really uncommon cases, there is no merger clause, but courts consider it integrated anyway, but that's still within the realm of possibility. Great. And then Middletown Concrete, which admittedly had a couple wrinkles in it, which made it a little more complicated. I think it's a nice case because in our trilogy of cases, it is kind of in the middle, right? And it shows like a softer approach than either UAW or Sierra Diesel. So what happened here? This is our pipe making machine contract. So we have the Saturn machine and the Neptune machine, and we have 3 contracts to buy the machines, and in addition, a separate acceptable performance letter. And the acceptable performance letter says these pipe making machines will make so much pipe per minute, and the contract said, 1, we're completely integrated, and 2, all of the promises, warranties, are in this contract. And so there are no promises aside from what's in this contract. And so again, we have the issue of, is the contract completely integrated? Now, the court would like to believe the contracts. The court takes what appears to be initially an objective view and says, well, the contract does say it's integrated, and we would usually believe that, but they just can't wrap their head around the idea that 3 separate contracts could all be complete. Right? You usually have 1 complete thing. Like, that's what it means to be complete. What do you mean? You have 3 complete things? Then how are they each independent and complete? Like, it broke the court's brain, and so they decided that there was no integration, no complete integration. I think there's a relatively simple solution, which is all 3 were part of 1 contract, and we just look at the 3 writings as 1 contract, but fine, they didn't. And so as a result, they found the terms, but I think it's partly because it didn't matter in the end, because they pulled that trick that Henry just brought up a few minutes ago, right? And by saying that, okay, the contract's only final, so we could add a term, but one of the terms is that all the promises, all the warranties are expressed in the writing. And by having an additional promise, that would contradict the written term that says all the promises are in the writing. And so in that case, they found that we're not going to introduce the evidence of the acceptable performance letter. And by the way, keep in mind that this was a case on appeal. The lower court said it's a complete and total integration. The appellate court said it's only final, but it doesn't matter. It was a harmless error. And so we talked about those issues as well. This was my opportunity to admonish you to always read the contract, not necessarily the whole thing, but if you're dealing with a merger clause, please, for the love of everything you believe in, to get an A, you want to put on your exam the clause you're discussing. And in particular, if you're dealing with the Parol evidence rule, you should verbatim include the merger clause and analyze it. Okay, so don't omit that step. When you're reading the case, when you're dealing with the facts, please highlight the merger clause and include it because the language is fundamentally important. The first thing we're going to do is ask the contract, are you completely integrated? And if it has something to say about that in the form of a merger clause, we're going to want to analyze that first using our tools for intrinsic analysis, right? And we may not need to pull out all 14 canons of construction. It might be really clear. And we have some examples of some clear ones. All right, we talked about those arguments as well. Right, so first step we asked in this case, right, just to give you an example, what did the court do? Took the first step that I suggested. What's step 1? What's the nature of the contract? And what did the court say in Middleton Concrete? Is the contract integrated? Yeah, the contract's final. It is integrated, although not a complete integration. Anyway, I would, in the interest of time, I'm running short, go ahead and you can review the case to see an example of how this played out, but we talked about that one last week. It also went through a set of factors. These are sort of extrinsic evidence factors to try to determine if the contract was integrated or not. And so you could add this to your list if you're interested of sort of, if you want something more concrete, something more tangible about what are reasons a court will find a contract is integrated or not, aside from the merger clause. And it talks about some of the other elements here. Having a merger clause is just one of them, but having the limitations of warranties showed the contract was more complete. The fact that they were reviewed by counsel, that they were signed and dated, that the parties were sophisticated, this all led the court to believe, there's all extrinsic evidence, mind you, but it led the court to believe the contracts were at least final. And so we have some factors there. So those are our 3 major cases, and United Auto Workers shows us the objective view of contract theory as applied to a merger clause, where we're going to believe the contract. In that case, the merger clause was clear and unequivocal, and so we were bound to it. The dissent took a subjective view and said, let's look at the intent of the parties to avoid a harsh result. Sierra Diesel came up with a different theory and said, this guy doesn't know what he's doing, and so as a result, he couldn't have possibly intended to be abiding by a complete integration. We're not going to integrate that contract. We'll admit additional terms. Middletown Concrete Products saw that these were sophisticated business people. They knew what they were doing, but it felt there was a logical inconsistency with the concept of three contracts, each being complete and exclusive, and found them not to be final, a more middle-of-the-road approach. All of them, though, showing how we're going to apply our tools of contract interpretation to understanding a merger clause. And why are we doing that? Because we want to understand the nature of the writing. All right, we're doing all that to understand the nature of the writing. And we can understand the nature of the writing through both intrinsic, merger clause evidence, and extrinsic evidence. So what does the parole evidence rule not do? It does not exclude evidence of the meaning of ambiguous terms, which we saw from our earlier cases. It does not exclude evidence of commercial context in a UCC case, as we discussed. It does not exclude evidence of subsequent modification because parties are free to modify their contracts, subject, of course, to the pre-existing duty rule. It does not exclude evidence of failures in contract formation, like as Dakota brought up, fraudulent misrepresentation. That evidence will come in. Look, a merger clause doesn't mean anything if a person signed a contract because they had a gun to their head. Nothing that they wrote down means anything. So the merger clause should, you go to court and you say, yes, I signed this, but I did it under extreme duress of a threat of death. The court's going to say, well, you signed it, so I'm going to believe what it says. No, at that point that gets ridiculous, even for a very objective theory. And we're going to have evidence come in of things like undue influence, duress, mistake, misrepresentation, and even claims that a contract is in violation of public policy. Right? Because all of those would undermine the existence of the contract itself. If the contract doesn't exist, the merger clause doesn't exist. Right? So we're not going to use the parole evidence rule to exclude evidence of a problem of contract formation. You don't have to worry about that this term because we're not being tested again on contract formation, but now you know. And it doesn't exclude evidence of equitable circumstances, which I'm not talking about now because that's a remedies thing. Okay, it also does not exclude evidence of a collateral agreement. So let's take a few minutes to talk about what is a collateral agreement. And this is the Seagram case. We actually have a couple cases in here, but this is a really tricky concept, and there aren't a 5-factor test or a 10-factor test. I wouldn't necessarily say it's abstract, because we get the idea. The idea is that if it's not supposed to be in the contract, it's collateral. But how do we know what's supposed to be in the contract? That's kind of hard. Let's take a look at the definition. The collateral contract doctrine is the principle that in a dispute concerning a written agreement, proof of a second agreement, usually an oral agreement, could be a second writing though, but a different agreement, a second agreement will not be excluded if that second agreement is independent of and not inconsistent with the written agreement. Independent of and not inconsistent with the written agreement. And if the information in the second agreement, usually the oral agreement, would not ordinarily be expected to be included. So now we have to figure out, are these terms that we're trying to add, we're not really, it's kind of, here's the mind trick, right? We're not adding them to this contract because you would not expect them to be in this contract. We are proving a different contract exists. Same parties, but a different contract. They can do that, right? You can have multiple contracts with one party. And so how do we determine when these terms are not additional to the contract that's integrated, but are collateral to it? Okay, turns out it's not that easy because it's a very fact-specific inquiry and these things can get quite litigated. But we at least have effectively a test, right? We have to have the additional terms are independent, not inconsistent, and would not ordinarily be included in the integrated agreement. Independent, not inconsistent, and ordinarily would not be included in the integrated agreement. How do we determine if that's the case? Well, let's take a look at the case of Seagram and Sons and see if we can't distill it. In the interest of time, I'm not going to do the Socratic dialogue on this one. I'm just going to give you the facts and talk it through because, as I mentioned, class today is 15 minutes short. And I do want to go over a couple of kind of questions at the end here. So let me see if I can help us through this. In addition, by the way, your casebook has really cut down the scope of this case, I think in part because all it does is show you one illustration of something that could come up in a multitude of ways. So I wouldn't cleave to this case like it's like the ultimate be-all, end-all. It doesn't provide some divine insight into the nature of collateral agreements, but it does illustrate one instance where a contract was collateral. So what was the holding of this case? We find in Seagram's a collateral agreement. What constitutes a collateral agreement? Right, and so a couple questions there for you. What happened in this case? Capital City is a wholesale liquor distributor. And by the way, by virtue of law, liquor has to be sold in a three-tiered structure. You have producer, wholesaler, retailer. That's true throughout America. So that means that you have this very important middleman role, which is required by law in the wholesaler. Capital City is one of these wholesalers, and they wanted to sell their business to the manufacturer, Seagram. And the thing is that these were wholesalers. That was their business. That was their livelihood. In fact, it was a family business. And so they wanted a promise that they could open up a wholesaler in a different area. And so they conditioned their agreement to sell their distributorship on Seagram's promise, really their vice president's promise, to relocate the family to a distributorship in a new city. Now, the question that will be presented is the promise to relocate the family collateral to the promise to buy the distributorship? Is the promise to relocate the family collateral to the promise to purchase the distributorship? Because the sale of the distributorship was a very nicely integrated agreement. It was professionally written. It was a big asset sale. It was a merger and acquisition type transaction. It was professionally done. And unsurprisingly, it had a merger clause. And it was pretty clear and unequivocal. And the court's not going to say they didn't really mean it in this case. So we have a merger clause. And the only way this promise is going to be enforceable is if it was collateral. So was it independent? Was it not expected to be included? Would it ordinarily be outside of an asset sale? And that matters because the parole evidence rule will bar the evidence that would modify or add a term. And just by the way, what's the nature of this evidence? Well, it's not going to modify a term because that contract didn't say anything about moving the family. Which also means, by the way, it didn't contradict, which as we saw was part of the definition of a collateral agreement. The asset sale, the sale of the distributorship, said nothing about moving the family. But it was completely integrated. And that certainly would be adding a term to it to say, in addition to paying you X million dollars, I will also move your family to Cleveland and set you up with a distributorship there. That's definitely an additional term unless it's collateral. Okay? So the defendant argued that the oral agreement was part and parcel. Part and parcel meaning it should have been in the contract. It was part and parcel of the subject matter. It was not collateral. An agreement to move a family is part and parcel of an agreement to buy their distributorship, says the defendant. Why does the defendant say this? Because they don't want to pay to move the family, right? They don't want to add the term. And they have a nice, complete integration. And so if it's part and parcel, it would be an additional term. Additional terms are not admissible to a complete integration. Failure to include it in the writing bars evidence, bars proof of its existence. The plaintiff, on the other hand, of course, will argue that the oral agreement is collateral. And so proof is not barred. All right? So why is it collateral? It has to make the argument that we would not expect this to be within the four corners of the document, that it really was separate. And so maybe the first thing that the court wants to say is the two old men, it talks about these lovely old men who negotiated this were good old friends. So that's one reason you wouldn't expect it to be in the contract, is because these two old men had a handshake deal. And these parties enjoyed a relationship of trust and confidence. And so one reason why we wouldn't expect it to be written down is because one party trusted the other to honor his handshake deal. It's interesting, at least. The court seems to really focus on that. Another issue was there was no integration clause. Now, the court did see good evidence that the contract was integrated, but it actually did not have a customary integration clause. And so that kind of opened the door to some questions about what was in there. And the contract, it didn't contradict anything, right? There was nothing in the contract, as I mentioned, that said, we're not moving your family. It didn't say, paragraph 43, we're not moving your family. It didn't say anything about that. They have a citation to a Mitchell case about moving an ice house. I won't get into that today. So the court then concluded that the oral agreement was collateral. Actually, there's another important fact I didn't mention here. Another important fact that made it collateral was the distributorship was owned by 5 people. And so the agreement to sell the distributorship was between Seagrams and the 5 owners of the distributorship. But the relocation agreement was only pertaining to 3 of those people. And that was an additional factor that seemed to weigh in favor of it being seen as collateral. Again, this is just one illustration. This isn't like the be-all, end-all, ultimate case in the universe, but it's meant to illustrate how the court will work through its reasoning in determining whether or not a contract term is part and parcel of a written agreement, or whether it's collateral too. And here, because the parties enjoyed a relationship of trust and confidence over years and would expect to rely on a handshake deal, because the contract didn't seem to have a fully established integration clause, it seemed to be integrated but maybe didn't have it written, because an agreement to move a family is different than an agreement to buy a distributorship, because 5 of the parties were involved in the sale and only 3 involved in the move. These are all facts that help the court come to the conclusion that the agreement to move them was collateral. But again, I think the reason the casebook shrunk this example is it's just one of a zillion illustrations. You can see a million contexts where a party would try to make this argument. And, it's not obviously part and parcel of the contract, but it's arguably part and parcel of the contract, arguably not. Each case would present slightly different facts. All right, back to the black letter law then. A collateral agreement under law is admissible, even if the associated agreement is a complete integration with an integration clause, because you wouldn't expect it to be within that. That contract is complete as to its terms. But if I have an agreement with Ryan to sell him my car, it doesn't mean I can't have a separate agreement with him to provide research assistance services. Same parties, but we wouldn't expect one to contain the other. And so we might have 2 completely integrated contracts which are collateral to each other, which are not part and parcel of the same agreement. Of course, could be a counter-argument. Well, I agreed to be your research assistant in return for your car. Okay, right? So there could be arguments that these are somehow related. And the defendant who doesn't want to honor the collateral agreement will come up with arguments that they are part and parcel. The plaintiff who wants to make arguments that the evidence should be admitted will argue that they are, in fact, separate and distinct.